As the district attorney here and a longtime prosecutor, from the outset, does this seem as though it is a slam dunk case, given the evidence you've amassed so far?
I would say there's no such thing as a slam dunk case. It is a case where we're still looking at the enormous amount of evidence, and we would never presume that it would be slam dunk. We will work very hard on this case to prosecute it just like we would any other case.
Carol, can you talk about what he's being held on, please? What he was arrested on, please? Can you tell us?
Carol, I'm aware that you may not be in office when the decision's made, but if it was your decision, would this be a death penalty case?
I don't think that that's a case that can be made in the abstract. There's so much that victims have to take into account, and victims will be impacted by that decision in an enormous way for years if the death penalty is sought. That's a very long process that impacts their lives for years. And so they will want to have, and we will want to get their input before we make any kind of a decision on that.
Special precautions being taken to protect his safety in jail.
That's my understanding, that he is being held in isolation.
Was this your first time seeing him, and what was your reaction?
It was my first time seeing him, and it is important that we treat him as we would treat any other defendant coming into the criminal justice system.
And Carol, at what point, I know that you said you want to talk to the victims before you just determine whether or not to seek the death penalty, but can you give us an idea of where in the process that comes and what we should be looking for?
The death penalty decision has to be made within 60 days of the arraignment. Okay. So it is months down the line still. But we will, over the course of those months, be talking with all of the victims, developing relationships just so that they know who we are and who they can talk to, and that will take some time in this case.